Hi, my name is Shazina and I am a family and childcare solicitor at Duncan Lewis. I am joined here today with my colleague Jade.
Hi everyone, my name is Jade. I'm a caseworker in the Family and Childcare Department at Duncan Lewis Solicitors.
So thank you for joining today's Instagram Live, which will be in relation to child arrangements. If you do have any questions, please put them in the comment box and we will hope to answer them as soon as they come through. So the first question that we do get from a lot of clients is, what is an actual child arrangements order? So when a relationship ends, there needs to be decisions made between the two parties in relation to the arrangements for the child. Whilst the parties are within their own rights to make those arrangements outside the terms of the court order, it's important to know that those arrangements are informal arrangements, so they're not legally binding. What that means is that if a party does not continue with those informal arrangements, it's not a breach of the agreed arrangements and it cannot be enforced. So a contact child arrangements order, it can assist the parties in outlining which parent the child will live with and how much time or duration of time the other parent will see the child. And what that can include and outline in a court order is the times the child sees the parent, the dates the child sees the parent, and also the duration of the time of contact.
So another question we get a lot at the firm is, who can apply for a child arrangements order? So there's various categories of people that can apply. Firstly, a party to a marriage can apply where the child is a child of that family. A civil partner in a civil partnership can apply, again, where that child is a child of the family. A person can apply if they've lived with the child in question for a period of at least 3 years. A person can also reapply for a child arrangements order where there's a previous child arrangements live with order in force. A person can also apply where that child is in the care of the local authority. The individual needs consent from that local authority to apply. A person who has PR, so parental responsibility of a child, can apply. PR can extend further than parents, for example, grandparents. Local authority foster parents can apply, providing that they've lived with that child for a period of at least 1 year before the application is made. And also a relative of a child can apply, again, providing they've lived with that child at least 1 year before the application is made. So if you believe you fit into any of these categories and you would like some further advice regarding this, you can contact us with our details that are found at duncanlewis.com.
Now, one of the main questions that we do get is in relation to what is the process and how does an individual actually apply for a child arrangements order. Now, currently at present, we are part of the Birmingham office, so we will be going through the process at Birmingham Family Court. There is a new process that has come into place. So on the 28th of May 2024, a reformed approach has been made to the private children law, which is launched in Birmingham, called Pathfinder. So obviously different courts have different processes, but the Pathfinder was introduced in the Birmingham Family Courts as a new scheme to improve the voice of the child by engaging early with children through various forms of communication. So there's a strong emphasis at the moment from moving away from the current nature of family proceedings by reducing the number of hearings, and this is also in the hopes that it would lessen the conflict between the parties and encourage more cooperative parenting. So the aim of a Pathfinder is for cases to be concluded quicker, so you're not going through the necessary emotional and financial distress of court proceedings, which can have an impact on individuals. So the pathway cases, it's hoped that they'll be completed within a period of 12 weeks, in contrast to the current time scales of current proceedings, which is 6 to 12 months. So of course, every individual's case would be different. So it would depend on your current circumstances as to how long the case would be, the duration of the case would be, and how long the proceedings would occur. So the new procedure states that a party must attend mediation, information, and assessment meeting before making an application to court. So this is through a third party mediator trying to mediate between the two parties to see if the matters can be resolved outside of court proceedings. A party can be exempt from mediation, information and assessment meeting, for example, if you are a victim of domestic abuse. So if mediation does not work or you are a victim of domestic abuse, we can file a C100 form to the court, issuing the application in to inform the courts as to what you're seeking in relation to the child arrangement contact. Once the application has been filed in, it will be picked up within 48 hours, and directions would be given to CAFCAS to prepare a child impact report within 40 days of that application being picked up. Now, this is different to the current proceedings in other courts where the child impact report does replace the current safeguarding letter and Section 7 report. Once that report has been filed by CAFCAS, a gatekeeping or case management appointment would be listed, where the courts would go through the child impact report and determine what the next steps are and whether a hearing is necessary. What the courts would generally do is list a decisions hearing. A decisions hearing is for the parties to attend, go through the child impact report, whether they're agreeable with what has been provided within the report, and if so, that can be used as a final hearing and a final order can be made, or if they're not agreeable, what directions need to be done, and a further review hearing can be listed as assessing whether the current arrangements are working in practice. And as we've stated, each individual's case would be different. So, for example, this is just a general overview of the process. If there are allegations of abuse, it may be that there is recommendations for a fact-find hearing to be listed to prove whether those allegations have taken place or not, and then further directions would be given. So if you are in need of further assistance with this, please contact us via the Duncan Lewis website, and we can go through and assist you as to what the process would be.
So what to do if you're served with an application for a child arrangements order? Firstly, we recommend that you contact solicitors for legal advice. As mentioned, you can find us at duncanlewis.com. You must complete a acknowledgement form C7 and file the same to court, so send the same to the court. Again, if this is something that someone needs assistance with, please contact the firm so we can advise you further. What happens if a party breaches a child arrangements order? You must note that a court order is legally binding, and failure to comply with the order will amount to contempt of court. As a last resort, a person may be committed to prison for contempt. A parent cannot be held in contempt by simply failing to take up the contact given. So if a party is in breach of an order, for example, the resident party or parent doesn't allow contact, an application can then be made to the court to enforce this court order, but this depends on certain circumstances.
Now, we do get a lot of inquiries in relation to legal aid funding. So Duncan Lewis does deal with a lot of clients who do obtain legal aid funding. So legal aid, it is a government-funded scheme that does help individuals who are on a low income access legal advice and representation. Once legal aid funding is granted, a legal aid certificate is provided to the individual. And what this does is it states that the legal costs that are covered, including solicitors' fees, counsel fees, and it can include disbursement fees as well, for example, court fees and any expert reports. However, it is important to note that a legal aid certificate, it does have limitations as to the work that is covered and also a cost limit. So in order for an individual to meet the threshold, it is quite high and it is a 3-part test. So the first thing that the legal aid agency will look at to see if an individual is eligible is the means. So a means assessment would be taken in relation to focusing on your income and assets. The legal aid agency would also look at your bank statements to see whether you're financially able to afford the costs on your own or you do require support. The second thing which is taken into consideration is a merits assessment. So this will assess whether there are legal merits to your case and whether you are eligible for funding. The third thing the legal aid agency will look at is gateway evidence. So in order to be eligible for legal aid funding, you have to evidence that you are a victim of domestic abuse, and this is for private children act proceedings. So there are different forms of gateway evidence that you can provide. This does include a protective injunction, such as a non-molestation order, a restraining order, or undertaking. It can be a letter from an independent domestic abuse or sexual violence organisation, such as Women's Aid. It can be a letter from a health profession, such as your GP, a letter from an expert service, such as CAFCAS. It can be a letter from a multi-agency, such as the police, local authority, a health visitor, or MARAP, and it can also be a police caution for domestic violence or proceedings in relation to the proposed respondent. Now, in order to be eligible for legal aid, you do have to meet this criteria. What would happen is if you do have a query, you can contact us and we would go through your eligibility to see if you are eligible for funding or not, and then we would be able to assist you further. Now, when people do apply for child arrangements contact orders, there are different types of contact that can be ordered by the court.
So one example is direct contact. So this may be where a child visits or stays with the person named in the order. So effectively, it's physical contact in person. Indirect contact is another example. This may be letter, telephone, email, or text message. And then there's also supervised or supported contact. This is ordered where there might be particular safeguarding issues in relation to the child. So the court may order this if they believe there's some risk for that child if contact isn't supervised or supported. And an example of this may be contact at a contact centre. Thank you everyone for joining the Instagram live today. At present, I don't believe there's any questions in the chat. So if you do have any more questions or you need any further advice on anything discussed, please contact myself or Shazina. Our email is in the chat box, so you can send us an email. And also our details are found on the Duncan Lewis website. Okay, that's great. Well, thank you everyone for joining.
Thank
hope
you.
it's been helpful. Thank you.
Thank you.
Thanks. Bye. Bye.